Good morning, Council. Welcome to the First District Court of Appeals. Our last case to be argued this morning is State versus Mugney. Mr. Hoffman, Ms. Cedars. Ms. Cedars, how much time would you like for rebuttal?
5 minutes, please.
5 minutes. Very well. You may proceed when you're ready.
Thank you. Thank you for having me. May it please the court, my name is Elise Cedars and I represent the city of Cincinnati, and I'm here on behalf of the appellant. As I noted in my brief, the trial court erroneously dismissed a case upon a motion to dismiss for lack of speedy trial. We disagree with that ruling and appeal to your honors. I'm just going to break down my argument and then answer any questions the panel may have. The Barker factors are employed to determine whether a defendant has been deprived of his constitutional right to a speedy trial. The first factor being the length of the delay, the second factor being the reason for the delay, and the third factor being the defendant's assertion of that right. Lastly, the fourth factor is prejudice to the defendant. As for the length of the delay, in this case, there's no dispute. It was 8 months and 12 days. I argued this at the trial level as well, but as this court said in Muhammad L, that Judge Winkler wrote actually, quote, in this appellant district, a delay of 9 months or more gives prima facie merit to a claim of denial of the constitutional based right to a speedy trial and requires the court to analyze the 3 remaining Barker factors. As I said, the length in this case is shorter than 9 months, so it is.
Well, but I don't think in Muhammad L or in the cases that we were relying on, we said that it has to be 9 months. I don't think we were drawing a line in the sand that says anything greater than 9 months satisfies this. Anything less, even if you're a day less, does not.
Okay. Yeah, I thought that kind of what I interpreted as is further analysis wasn't necessary, but Judge Barry determined that it was necessary. So we did go into the analysis on the 3 remaining Barker factors anyways. The reason for the delay is the second factor, and it's neutral at best in this case. There's no bad faith. This wasn't a deliberate attempt to delay the process, just a general lack of police diligence. An overworked third shift officer responded to a scene and did what he could at the time with the resources he had. He was, quote, going run to run as he testified. He even said, we didn't have any free time to go look for the defendant.
Well, I guess my concern about that argument, I mean, I can certainly have sympathy for people being overextended, but like why couldn't he hand that off to someone else? And if we agree with you, are we suggesting that the state always gets a pass if they can make an argument that an officer is overworked?
I don't think that the state always gets a pass. I think when it's less than 9 months, 8.5, being with the facts here, the officer was working third shift. It's in the middle of COVID, so there's less officers. I think the civil unrest for the George Floyd protests were about 10 days after this. And then this officer was also put on the ATF gun task force very shortly after this case. So I think that it's case specific. But in this case, if the court finds the officer to be negligent, the state's reason for the delay is neutral at best. And then the third factor, it's undisputed that Mugney asserted his speedy trial right in a timely manner. And this factor does weigh in Mugney's favor. The last factor, which is probably the most important in terms of today's argument, I would think, is prejudice to the defense. As instructed by this court in Bush, the court should assess prejudice in light of the interests where the right to the speedy trial was designed to protect, including 1, to prevent oppressive pretrial incarceration, 2, to minimize anxiety or concern, and to limit the possibility that the defense will be impaired. The first 2 interests are not implicated here because he was not incarcerated before his warrant and arrest, or between his warrant and arrest, and then he didn't assert that he suffered any anxiety or concern during that period. Regarding that third interest, he also failed to show prejudice from the city's viewpoint, presumptive or actual. So the 8 month.
But I guess my question is, and I was looking back over your brief about this. I mean, the trial court made specific findings on prejudice. I don't see you all discussing those in your brief.
So are you referring to the body worn camera?
Mm-hmm.
Yes. So yeah. So for the body worn camera, it was erased just according to CPD's retention policy. So the defendant says that he lost the ability to impeach the victim if she testifies with inconsistency, because it would show her statement, her injuries, and the crime scene itself. Mugney still had access to the police incident report and the state's witness list provided in discovery, and the 911 call also still existed. In fact, the victim was readily available and present at the motion to dismiss hearing because the trial was originally scheduled for that same day. The defense could have interviewed her in the hallway prior to the motion being heard. We don't know if he did. That's not in the record today, but he could have. So the city submits that nothing in the record indicates that body-worn camera evidence would be materially exculpatory. And to the state's knowledge, the body-worn camera evidence would be considered inculpatory at this point. The possibility that the victim will testify inconsistently and therefore Mugney could use body-worn camera evidence to impeach the victim is merely a possibility. And then these blanket assertions of speculative prejudice cannot suffice to show that he was actually prejudiced.
Well, if the trial court makes prejudice findings, do we have to defer to those or not?
I think that he found that the body-worn camera might have been prejudicial. The lack of the body-worn camera might have been prejudicial, but I will say I think that in terms of the fact that he wasn't contributing to his delay in prosecution, Judge Barry wrote, as far as can be determined, defendant remained a Hamilton County resident and didn't evade prosecution. And I don't think that this finding is reasonable or supported by competent or credible evidence. He didn't testify. So I do think a few of those findings weren't supported by competent and credible evidence. So possibly you guys may need to look at the facts again, but other than that, I just think that this is a speculative prejudice case. There's no actual prejudice. It might be a different case if, there was some other witness on the body-worn camera and she gave her address and number and now we can't find her. But for all we know, this is material.
But we don't, but I think the problem is we don't know because we don't have the body-worn camera. And I guess this isn't the first case that we've confronted this issue. With the city's policy of deleting these after 90 days. And I guess it really, in my mind, begs the question of why isn't the city, knowing that they have an arrest warrant out for someone like this, automatically flagging that to be preserved to avoid these kind of issues in the future?
I agree with you. I think that it should be looked at, and I think CPD should, if the standard is 9 months or 8.5, then we should extend our body cam to that. But for now, what we're looking at is there's nothing in the evidence that suggests that it is exculpatory. The officer testified that it was just the victim there at her house. She had injuries. And so at this point, I don't think it is exculpatory and thus not actual prejudice. So accordingly, I don't believe that Mugney was deprived of his constitutional right to a speedy trial. Does the panel have any other questions?
Ms. Cedars, what efforts were made by the police officers to execute the warrant?
So the only efforts made were the victim told the officer the date of birth and name and known address of the defendant to her. But the officer testified that he was going run to run that night and he didn't have time to go to that address that she gave. I will say, though not described in the record, the reason that the complaint says Juliad Mugney 100 no home is because he doesn't have a home in the system. So all he was going with was what the victim said the last known address of the defendant was.
That argument wasn't developed during the trial.
Yes, correct.
Okay.
Yeah, I once the officer told me that he got an address from the victim, I didn't think that it would benefit really to ask that question, but I probably should have looking back.
Any other questions?
Yeah.
Okay, thank you, Ms. Cedars. You'll have your rebuttal. Mr. Hoffman?
May it please the court, Ms. Cedars. Can the court hear me all right?
Yes.
Thank you. I see this case as, I think, in an unusual issue in this case I'd like to discuss has to do with the address, whether the fact that the trial court made an assumption that my client had an address. And I think that it weighed upon at least the first two factors in the way the trial court looked at them. I think if the trial court had known that my client did not have an address, as the complaint suggests, then I think this all would have, the case would have changed the result. I think that and so because this wasn't explored by the prosecutor, the fact that the homeless status of my client wasn't brought to the attention of the trial court, it constitutes a forfeiture of that fact.
Well, I think she was agreeing with you on that point.
Okay. But anyway, I just wanted to note that unlike a defendant, the forfeiture, there's no way around it for the state. You don't have a claim like ineffective assistance of counsel for the prosecutor or a plain error rule where a substantial right of the accused is implicated. So I think the court is pretty much bound by the fact that this that the trial court's assumption that there was an address in the record is going to have to control as far as what the court can do with that fact, what the complaint about my client being homeless. I don't think that's going to be a basis for reversal. As the court pointed out, this court announced a nine-month floor for the presumption of prejudice, and that would allow courts to assume prejudice for periods exceeding 9 months, but it wouldn't work the other way around. You shouldn't say that because the delay is less than 9 months that you can't just assume that there's no prejudice. And I think for the appellant to prevail, there would have to be an affirmative demonstration of error. You couldn't just point to the fact that the delay was less than 9 months and just win based on that, just because of the role of the appellant in the appellate process. And also, I learned in this case that federal courts use generally an 8-month period of delay. And I think that since we're talking about the Sixth Amendment, a federal constitutional right, there should be some obligation to recognize that 8-month period when the court is ruling on that kind of a right.
I looked at that 8-month period, but when you peel back the layers of that onion on that, it's not like there's overwhelming authority on the federal side. I think it's just like a scattered district court or two. So it's not like a universal rule where the federal courts have said, there's a line in the sand, 8 months forward is fine.
Well, I did note that there was some difference, but I kind of, from looking at it, it looked like the majority of the courts did hold that there was an 8-month rule. And it looked like it wasn't just the district courts. I thought there were appellate courts that held that. But I don't want to get into the. I mean,
well, I'm sorry. Did you cite any of those in your brief?
Well, the United States versus Johnson case. That was an old case, but that's an appellate court case, and it did. I'm quoting. It said 8-month delay, presumptively prejudicial. Where the oh no, that's not it. Sorry. Hang on a minute.
Okay, I see the citation of that.
It looks like it might be United States versus Gregory. I think that's the one on page 3 of my brief.
Okay.
Anyway, I think that is the length of delay in this case does not the 8.5-month delay does not preclude a finding of presumptive prejudice under the circumstances, particularly with the testimony about the body-worn camera. The reason for the delay is the trial court found that there were no efforts made to serve this warrant. Again, it was under the assumption that you didn't have an address. I mean, that there was an address, but there was nothing done about it. I think the standard operations for dealing with a warrant where a person's homeless would pretty much be what happened in this case. But again, because it wasn't pointed out, I don't think it's a basis for reversal to say that the trial court, was making the wrong assumption and finding that the second factor weighed in favor of the defendant.
What about the trial court's finding that he would not be able to present an alibi defense? What was the evidence of that?
Well, I was aware of the body-worn camera, but that finding, it takes me by surprise on that. I guess the trial court made a finding that there was an alibi defense that couldn't be made. I wasn't aware of the fact that an alibi was asserted, but I guess that was part of the argument that defense counsel had made.
He says the prejudice exists because the 90-day body cam retention policy had long expired. The officer testified he believed the footage was not preserved, is no longer available, and defendant can no longer assert an alibi defense. So I was wondering that last part, what the basis was for that.
That's a tough one. I'm not really sure what the trial court's basis would be based upon what happened at the hearing on the motion to dismiss. Either my client would be in the body-worn. Well, no, actually, a body-worn camera was what recorded the interview with the victim after the fact, and my client had left the scene. So I'm not really sure if her statements implicated my client. I'm not sure how the alibi, how that would have affected the an alibi defense, to be honest with you.
Mr. Hoffman, I'm
Yes.
interested in the prejudice argument. Where exactly is the prejudice to your client?
Well, as the trial court stated, it was the destruction of the body-worn camera footage. That was elicited by counsel during the testimony of Officer Chiapponi. He talked about the 90-day period, the retention period, and how after 90 days the body-worn camera, the footage is recycled or destroyed, not kept any longer. And so I guess the demeanor of the victim, the injuries depicted on the body-worn camera, all that evidence would have been taken away or destroyed. And so it could have borne upon her credibility, her degree of excitedness or something like that. The allegations were that she had been confined for 2 days and subjected to domestic violence. And so this body-worn camera footage would have possibly provided evidence that would have enabled a defense attorney to cross-examine her more effectively as to the emotional state that she was in at the time she was interviewed by the officer. So it had potential. It had potential. Obviously, since it doesn't exist, you can't point to anything specific that would demonstrate actual prejudice. If there are no further questions, I would ask that this court would affirm. There's no do-over for the state with respect to the forfeiture rule, and as the defense has the ineffective assistance of counsel or plain error rule to allow that kind of thing, but there's no such rule for the state. And so this, the way this case was set up, the way the facts were presented to the court had little choice but to grant the motion to dismiss. And because of that, I would ask this court to affirm the judgment. Thank you.
Thank you, Mr. Hoffman. Ms. Cedars, you have 5 minutes.
Thank you. I wanted to kind of hone in on the Sears finding and how this is different than that, because the trial court compares this case to Sears, and so does the appellee in this case. First of all, obviously the delay was shorter than 9 months. As for the reason of the delay, it was a negligent but neutral delay. When Sears occurred in 2005, decisions and briefs used to be much smaller, as you guys know, but I was able to gather a few things. One thing mentioned in the defendant's brief in Sears is that the trial court relied on the fact that and stated that there is no reason for delay, quote, no explanation. The case at hand differentiates in that the explanation has been given. Officer Cipollone said he was too busy with his duties as a D1 police officer on 3rd shift, middle of the pandemic, fewer officers on duty, especially 3rd shift. And thereafter this, the civil unrest began about 13 days after. His summer slammed. Like I mentioned, he went to ATF. Another reason for the delay is Mugny's.
But I guess the problem I'm having with that is it makes it sound like it's solely that officer and no one else who can serve the warrant or try to find this guy. Like, why is that the case? I mean, because otherwise, like, the officer retires and then you're like, well, he's gone. Nothing we can do about it.
Honestly, I think when an officer is assigned to a case, that particular officer is in charge of serving the defendant unless it is in the fugitive unit. So for these misdemeanors, that's why we have so much case law on misdemeanors with these issues, because they go into the central warrants and then they don't disappear, but until the person's arrested again, we don't have officers looking for them. Like if somebody were to retire, I don't know if there's like a list that people would go back to and send people out on. But this officer in particular, I think, did give a reason as to why there was a delay, and that delay being pretty short, 8.5 months. I do just want to note Mugny's actions. And, you know, I don't know, the trial court didn't go into this, but he did allegedly flee the scene. So it could be argued that he made affirmative steps to avoid detection and apprehension. And if he purposely contributed to that delay, it would weigh heavily against him. Sears is also different, though, because nothing in the record indicates that Mugny lived at the address the victim gave. He didn't testify at the motion hearing. We don't know his real whereabouts or address at the time the crime was alleged to have occurred or thereafter. In Sears, the defendant testified and remained at the same address throughout this period, did not make any attempt to leave the jurisdiction or to avoid service. He testified, and Mugny didn't testify. So we can't say the police would have found Mugny even if they tried. We don't know if they could have found him at a listed address or not. Lastly, as to prejudice, just to touch on this again, Judge Berry did make this legal conclusion that this court should review now, because it's not just enough to say there's no body cam, there's prejudice. There has to be more testimony and specific finding as to why its absence is prejudicial. And that was not given to us by the trial court. So yes, the body cam was deleted only due to the retention period, but no bad faith exists. Mugny wants you to believe that deleted body cam could equate actual prejudice, but as this court noted in Rogers in 2019, the defendant must particularize prejudice. Reliance on dogged is not enough. Generalities won't suffice. And to answer your question earlier, to Mr. Hoffman, Mugny's trial court attorney was grasping at straws. So just because maybe someone could impeach a witness if their statement was inconsistent, or just because maybe someone could remember their alibi if the police caught them sooner, it doesn't equate actual prejudice. So this court shouldn't set that precedent, and the city submits and close that expanding the previous ruling, the Sears ruling, is dangerous and a slippery slope for more crimes going unpunished. So thank you for your guys' time. If you have any more questions, I can answer.
Any other questions? Okay. Thank you, Ms. Cedars. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written opinion, and I hope you both have a great day.
You too. Thank you so
that
much.
Concludes the oral arguments today for the First District, and appreciate everybody's time.